I wanted to get to a bit of news that was in our newspaper in the last day or so. Last fall, you suggested that fellow justices sign a letter to the citizens of the state, essentially apologizing for the altercation that occurred. I wonder what you were hoping to accomplish with that letter.
Well, the letter arose out of a very unfortunate incident between Justice Bradley and Justice Prosser in June of 2011. And that matter proceeded through an investigation by a district attorney, deciding not to proceed on it, and then ending up at the Judicial Commission where there were charges filed against Justice Prosser. Because we have a statute, 757-19-2B, that says if you are a material witness, you cannot be a judge. And also because the common law of the state of Wisconsin is that every person deserves an unbiased, independent decision maker. I could see that we were not going to be able to proceed through the Judicial Commission because the eventual decision maker is going to be the Wisconsin Supreme Court. And during that incident, there were 6 justices there. The incident really breaks my heart. I mean, it was very unfortunate for the 2 people involved, but it so diminished the court in the public's view, so diminished it. And I really believe that the court needs to clear the decks with the public on this. So we have a schedule where we start up sitting together the first Tuesday after Labor Day, and then June 30th, we don't sit together. And I always have summer projects every summer. So in July and August, I had some time where I didn't have to be doing things with other members of the court. And I did some research on the court's inherent authority to discipline its own members, hoping to find some things that might be helpful. And what I found is that the court does have the inherent authority to discipline its members. And I thought it would be helpful to get a discussion going with members of the court to see if there was some way we could, all of us, agree on some mechanism for clearing the decks with the public on this just awful incident and trying to repair some of the damage that was done to the court as an institution, irrespective of what happened to the justices, just for the court as an institution. So what I decided after my research, I wrote a long email. It was really like a memo, but it was on an email. And I'd done a lot of research and had legal foundations for what I suggested, is that we all sign a letter, basically a public apology, which is, you know, acknowledging that that conduct is just so inappropriate and assuring the public that they could rely on us to respond and react to one another in ways that are appropriate to the office they give us the honor to hold. And I said it doesn't have to be my letter, but I wrote a letter, and I hoped that we would be able to come to some conclusion at the start of this term. The Chief Justice would read it from the bench before oral argument, and we could move on. And we could begin to repair the damage that was done to the court as an institution. So my focus was really on the court as an institution, because I think there's been a lot of damage done to it. I didn't get a consensus from everybody that that's what they wanted to do. I am hopeful we will continue to talk about it. With this campaign ongoing, I haven't been able to get back again and try to get us all together and sit down in conference and say, if this wasn't the way to proceed, how should we proceed? Because we have that obligation, I believe, to the public. So it was my efforts at trying to get something to go forward. It didn't have to be my letter, and I suggested if other people had a better suggestion, I was happy to hear that. I just haven't had the bandwidth, frankly, to pick this up again and go. But it's very, very important, and I will proceed further on it because I think the court has an obligation to the public.